Compounding of offences. What is compounding of offences? Well, the word compound means to settle a matter by money payment in exchange of any other liability. Compounding is a settlement mechanism. A settlement by paying the penalty instead of facing the prosecution for the offence which is committed. The meaning of compounding of offence is not defined under the Companies Act of 2013. It's basically nothing but an admission of guilt by the person who has committed the offence. In compounding of offence, you are basically saying, sorry, I made a mistake, please forgive me. You are saying this to the registrar of companies or any other regulatory authority. In the process of compounding, the person may either on his own motion go for compounding, or when he receives a notice from the registrar of companies, he can go for compounding of the offence. In compounding, the party who has committed the crime, who has committed the offence, admits the commission of default and makes the application for compounding of that particular offence. So basically, he is admitting a mistake and asking for forgiveness or pardon and promising that he will not commit the mistake again. So the defaulters agree to pay a penalty for the offence or non-compliance of law, and this is basically called as compounding of the offence. Compounding is essentially a compromise between the regulator and the person committing the offence. Compounding crimes consist of receipt of some kind of consideration, what we call as the compounding fees. That is like the fine which you pay for the offence which is committed. And in return of this, there is an agreement and an assurance from the side of the regulator that they will not prosecute the person who has committed the crime, because he himself is coming on his own motion and admitting the crime or admitting the offence. Now let us look at section 441 of the Companies Act of 2013. So this section says that the power of compounding the offence under the Act lies with three authorities. The first one is the National Company Law Tribunal, the second one is the Regional Director, and the third one is the Special Courts. So this is something new. We also have a video on special courts which you can check it out. Now let's see compounding of offence by special court under the Companies Act. So here section 441 subsection 6 says that special court can go for compounding of offence. That is, any offence which is punishable with imprisonment or fine, or imprisonment and fine, it should be compounded only by a special court and not by any other authority. You might have heard about compoundable and non-compoundable offences. In the name itself, you will understand that some of the offences which can be compounded and the other offences which cannot be compounded. So basically, compoundable offences are the offences in which the complainant can compound the matter with the accused as a matter of right, and such right is not available in the case of non-compoundable offences. A compoundable offence is always a lesser degree offence, or what we can call as a smaller offence, which usually has a smaller term or a smaller fine. When an offence is compounded, the party who has been aggrieved by the offence is compensated for his grievance and all the trouble that he went through without any mistake of his. Generally, the compounding of offences is permitted in case of procedural violations which are not affecting the interest of the company or the general public. This was a brief video about compounding of an offence. Compoundable offence is always a lesser degree offence which is punishable for a shorter term or only a fine. To get more such videos on corporate law, please subscribe to our channel Ekcel Academy. If you want any videos on specific topics, please feel free to ask in the comments below. We will be happy to help you.